मैं तो इससे बिल्कुल ही ये जो अल्फाज का चुनाव है ब्रोई साहब का, जुडिशरी डिपार्टमेंट, मैं पढ़ रहा हूँ इनके लफ्ज़, जरा एक सेकेंड, द जुडिशरी डिपार्टमेंट इज द प्रॉपर पावर इन द गवर्नमेंट टू डिटर्मिन वेदर अ स्टैच्यू बी और बी नॉट कॉन्स्टिट्यूशनल। मैं तो बिल्कुल इससे इत्तेफाक नहीं कर सकता हूँ। हम ना तो गवर्नमेंट के डिपार्टमेंट हैं, ना ये पावर गवर्नमेंट में वेस्ट करता है टू डिटर्मिन। ये जुमला तो मुझे तो हमारे आइन के तसादुम में है। ये
जुमला वेरी रिस्पेक्टफुली सबमिटेड। चौधरी साहब, मुझे भी ये जुमला इस हद तक अच्छा नहीं लगा। चौधरी साहब,
आप मातहत डिपार्टमेंट बना दिया गवर्नमेंट,
उन्होंने डिपार्टमेंट बना दिया विच इज नॉट। हम तो सेपरेशन ऑफ पावर्स
ऐसी पेश कर रहे हैं हमारे
सामने। साहब, वो बेसिकली जी
चौधरी साहब इधर
जी जी
आप अगर पेज 14 पे आ जाएं, ये किताब छपी है 1958 में।
जी दुरुस्त।
जब पहला मार्शल लॉ लगा था और इस कोर्ट ने पहले मार्शल लॉ को वैलिडेट किया था।
जी दुरुस्त।
क्या ये उस कॉन्टेक्स्ट में देखा जाए?
कि with the passage of time, definitely, not what already flown under the bridges, I would not say so, because जितनी judgment उसके बाद आई, उसके बाद तो मार्शल लॉ को हमने मुशर्रफ के मार्शल लॉ को
वकील साहब जरा here please. This book ब्रोई साहब की किताब was published in May 1958. मार्शल लॉ लगा था अक्टूबर 1958. This book predates martial law. It was, I think Broi Sahab regarded it as an elementary book, if you look at the preface, as an elementary book to teach constitutional law, but it has become his magnum opus, rightly so, but it was published prior to martial law.
That's correct,
It has nothing to do.
जी मैं गुजारिश करूँ
आप जो एक सेकंड जरा अभी आपने जो हमें पैसेज पढ़ के सुनाया ना, जरा वापस उस पे आइए। ये ब्रोई साहब के पास नहीं है, ब्रोई साहब is just quoting someone. This is Chancellor Kent, I think.
ये अभी तो मैंने
ये जो है ना, ये जुडिशरी डिपार्टमेंट और गवर्नमेंट, ये अमेरिकन लॉ की इस्तिलाहात हैं। वो मतलब उनका ये नहीं होता है उधर के, ये उधर भी ट्राइकोटोमी ऑफ पावर, सेपरेशन ऑफ पावर्स इज अ वेरी फंडामेंटल डॉक्ट्रिन ऑफ यूएस कॉन्स्टिट्यूशनल।
वही से हमने एज अ मैटर ऑफ फैक्ट
कॉलिंग रिगार्डिंग इट गवर्नमेंट कैपिटल जी द स्टेट, it means it's one of the three branches of the state. It doesn't mean, and these are not Broi Saab's words, he is quoting someone, I think.
ये लेक्चर है, लेक्चर 20 commentaries on American law, volume so of Philadelphia.
उन्होंने अमेरिकन जजमेंट्स भी साइट की।
देखिए चौधरी साहब, because he is quoting someone ना, तो obviously उस कोर्ट में तो उसी की जबान इस्तेमाल होगी ना जो उस ऑथर ने की है।
जी दुरुस्त।
बट ब्रोई साहब का मकसद यहाँ पे था to elaborate the concept. The concept of separation of power, where, as we know, the famous words from Chief Justice Marshall in Marbury versus Madison, it is the province of the judicial branch to determine and say what the law is. That is being perhaps more broadly explained. This is from a book of 1889, so it's part of settled constitutional law.
लेकिन बुनियादी उन्होंने ये सारे लॉज जो है ये मेडिसिन वाला बेसिकली
हमारे पास
इसका भी रेफरेंस
देख लिया है। ये पैराग्राफ 28 आप पढ़ रहे थे, वो पढ़िए।
जी जी, पैरा 28 जो है,
power to declare laws unconstitutional, not inconsistent with giving effect to the will of the people.
ये बुनियादी तौर पे अगर इजाजत दें तो इट्स वेरी रेलेवेंट। When the courts of law hold certain laws to be unconstitutional, their declarations cannot be construed as defeating the will of the people as expressed in the legislatures of the country. From what has been said so far, it would be apparent that the legal sovereign
that ordains and
establishes the constitution is the people, but this term ought not to be confused with the people as the voters who have returned their representative to act as legislators. The people as a historic community must be distinguished from people as a community of the entire living population with their presidents and predecessors and successors. The people acting solemnly and deliberately, says Professor Willoughby in his book, The Constitution of the United States, in their sovereign capacity, declare that certain matters shall be determined in a certain way. These matters, because of their great and fundamental importance, they reduce to definite written form and declare that they shall not be changed except in a particular manner. In addition to this, they go on to say, in substance, that so decided is their will and so maturely formed their judgment upon the matter, any act of their true will. Therefore, when the courts declare void legislative acts inconsistent with the constitutional provisions, the judges are giving effect to the real will of the people as they have previously solemnly declared. Thus, in effect, the declaring law and constitution, the judges are administering the real will of the legal sovereign. Will, which having regard to view that they take impugned law, has been thwarted by the representative of the people considered as a historic community. My submission is very respectfully, basically, in this para, the will of the people, that is, and that is what is preamble of the Constitution of Islamic Republic of Pakistan.
Sir, if I may ask you a question, the question here is, I think, of legislative competence. It's not perhaps how quote-unquote good or quote-unquote bad this law is. The question that is perhaps agitating the petitioners, from what I have understood from your submissions, you as well, is there legislative competence? If the answer is there is legislative competence, then the matter proceeds in one direction. But if the answer is there is no legislative competence, well, then that ends the matter. As you are well aware, the technical term, and I'm emphasizing this is the technical term of art used in constitutional law, that where a legislature, federal, provincial, doesn't matter, tries to make a law beyond its competence, the technical term is that it is a fraud on the Constitution. Those are very strong words. So here we have to focus, and this is perhaps what you are trying to tell us, if I'm trying to understand what you are saying, that it matters not whether this is a quote-unquote good law, whether it says that the Supreme Court should give priority to this class of case or that class of case or whatever else that this law may say or Parliament may in future say. The question is, does Parliament have the legislative competence to regulate the Supreme Court in this manner? इसमें एक section है, वो आपने अभी हमें पढ़ा नहीं हमारे सामने. I think it is section 7.
Section 7, sir, I just referred to.
वो जो है, अब देखिए ना, अब ये an application pleading urgency or seeking interim relief shall be fixed for hearing within 14 days from the date of its filing. Now this may, some may say this is a quote-unquote good thing. Question is, can the Parliament regulate Supreme Court down to this nitty-gritty level? Is this what independence of judiciary and separation of power is all about? इस पे जरा kindly हमें कुछ बताइए.
My Lord, very respectfully, I just, since certain things were going on in a certain manner, I prepared this brief starting from the oath itself, my Lord. As a matter of fact, when we say that to preserve and defend and three words.
इकराम साहब इकराम साहब
उनको जवाब दे
इकराम
मैं अपने मदर साहब ये जवाब दे रहे थे मुनीर साहब
एक और चीज उसमें पूछ लूं. इकराम साहब ये इधर देख लीजिएगा राइट से आपके सॉरी ये आप 58 की जो बुक कमेंट्री पढ़ रहे हैं इस वक्त तो लेजिस्लेटिव कॉम्पिटेंस पे जो आप बात कर रहे हैं